Welcome to the afternoon session of the Consumer Goods Council and ENS Africa Legal Annual Summit, which really we've put together for our clients and members respectively to help them navigate the ever-changing and often complex legal and regulatory landscape, and for us to essentially share best practice. In this afternoon session, we'll start first with environmental law, and the topic there is consuming in the context of EPR and ESG. And we have two speakers. The first will be James Brand, and then later on we'll be joined by Carlyn Frittelli Davies. James, just to a brief biography for you about you. James is a senior associate in ENS's Natural Resources and Environmental Department. He specializes in advising the agribusiness sector and has particular expertise in advising on water law. And then now for Carlyn Frittelli Davies, she's a consultant in the Natural Resources and Environmental Department. She specializes in environmental and mining law, and in particular on the regulatory aspects of the establishment, enclosures, and rehabilitation of mines. Her expertise also includes advising on environmentally related authorizations, appeals, reviews, administrative and criminal proceedings, and environmental indemnities and warranties in relation to commercial agreements. Well, I'll hand over to you just now, James. I just want to find out from you, Taryn, are we good with the number of people that have participated? Because it's gone down a bit. I'm just presuming that, well, it's going up. So maybe just give it 2 more minutes, because some people are saying that they're logging on, and then we can start.
Okay, perfect. Yeah, I think it's going up slowly.
Yeah, it's going up. There's a hand up. I'm not sure. Sharad? Is your hand up?
They just need to unmute.
I thought the sound from James was a bit distorted, and I don't know whether the problem's on my side or not.
There's a feedback when you're speaking. James, do you want to say something just to hear, for people to hear if you're clear enough?
Yeah, sure. I also heard feedback from your side, so I'm not sure what everybody can hear when I speak now, but I was definitely picking up a bit of feedback when you were speaking. How does this sound to you guys?
This sounds great. So Sharad, you're not on two devices by any chance, because that normally happens to me when I've got two devices at the same time.
No, I'm not.
Yeah, because from when you speak, there is feedback coming through.
Okay, probably the problem's on my side if nobody else is reporting it.
Yeah, hopefully it will get better. Well, I think we're good to go. Without further ado, James, can I hand over to you to take us through this session?
Yeah, sure. So thanks for that introduction and welcome back, everybody. I hope you had a good lunch. Today I'll be talking about food loss and food waste in the context of ESG and the ESG inquiry, which relates to sustainability. So for those of you who've not yet come across the acronym ESG, it stands for Environmental, Social and Governance, and is a sustainable finance term that seeks to redirect finance to sustainable enterprise. The ESG inquiry is an emerging area and is part of a global megatrend that seeks to provide increased focus on operating sustainably throughout the value chain. How companies address food loss and food waste throughout their value chains therefore becomes important if they are looking to demonstrate that they are sustainably aligned, so as to attract types of finance that are earmarked for ESG investment. Many of us were told by our parents, or currently tell our kids, not to leave food on the plate because other children are less fortunate and don't have any food at all. But masses of amounts of food are lost in the value chains that do not even make it onto our plates. And this really, in a nutshell, is what I'll be looking to unpack and explore a bit more in this presentation. This year, the United Nations marked its first ever observance of the International Day of Awareness of Food Loss and Food Waste on the 29th of September, so just the other day. And it seems that globally and locally, we are starting to shine a light on this important issue. Next slide, please, Taryn.
coming through.
Tarek, are you battling to move the slides from your side as well?
It is, yeah.
I've just moved it.
Okay, so from my side, I still look like I'm on the first slide, but if it has moved on to the second, that's great. So I'll continue. And really from here, it's just identifying the problem. So 30% of local agricultural production in South Africa is wasted each year, which is equivalent to an estimated 60 billion a year, or about 2% of GDP. South Africa generates an estimated 12.6 million tons of food loss and waste per annum, a third of the food available. It's estimated that every ton of edible surplus food could make an estimated 4,000 meals. In a country where 30% of households are at risk of hunger, 31% experience hunger, and with 13 million children living in poverty, this is clearly an unsustainable situation and needs to change. Next slide, please.
So James, it looks like it's only moving from my side.
I'm gonna try share it again.
Okay.
Okay.
There we go.
Yeah, so that's effectively the nutshell of the problem that I've just discussed. Yeah, that's the slide for now. So thank you. So in 2015, the United Nations General Assembly launched the 17 Sustainable Development Goals, which most of you probably would have heard of. The acronym for that is SDG. And they basically set out a blueprint to achieve a better and more sustainable future for all that are intended to be achieved by 2030 as part of the 2030 UN agenda. The principles include such things as universally available clean water and eradicating hunger and poverty, for example. The UN SDGs are expected to require significant amounts of capital to achieve this ambitious plan. But the SDGs are not binding on corporates as well as national governments. So getting such lofty ideals to be implemented in practice is where the ESG movement comes in. Traditionally, pressure on companies to achieve sustainability-related standards would have come from NGOs, but in general terms, corporates would not necessarily be as responsive to these demands, as sustainability and ESG-related criteria were viewed as nice-to-haves and not business essentials. What ESG seeks to do is bring sustainability-related criteria or externalities into the decision-making process as regards to where capital is allocated by institutional investors. As a result, what you start to see is the same corporates starting to respond to pressure that is now coming not just from NGOs, but from investors as well. This is because you're starting to speak the language of the capitalist system, which is really to redirect capital to sustainable enterprise. If an enterprise or company or activity is ESG aligned, it will enhance its ability to attract ESG related to sustainable finance. Next slide, please, Taryn. So scientists note 9 planetary boundaries beyond which we can't push Earth systems without putting our societies at risk. These are climate change, biodiversity loss, ocean acidification, ozone depletion, atmospheric aerosol pollution, freshwater use, biogeochemical flows of nitrogen and phosphorus, land system change, and release of novel chemicals. Quite a mouthful. The point to take away from this slide is that humanity, according to the scientists, is already existing outside the safe operating space for at least 4 of the 9 boundaries, as indicated in red on the slide. The way in which we produce and consume food plays a significant part in either providing a stable platform for the ability for our societies to thrive, or it can create instability by impacting upon the foundations of our biosphere. It can be anticipated that over time, how we produce and feed the 7.7 billion people on Earth will gain acute focus going forward. Next slide, please, Taryn. The relevant SDG, or Sustainable Development Goal, that I mentioned earlier that seeks to ensure a reduction in food loss and food waste is SDG 12, that seeks to ensure sustainable consumption and production patterns, including a specific target in SDG 12.3, which is on the slide here, which seeks by 2030 to halve per capita global food waste at the retail and consumer levels and reduce food losses along production and supply chains, including post-harvest losses. So this sets the platform for our collective ambition or aim. Next slide. Why we need to get to this point is because there is a general recognition that the current global food system is unsustainable, dysfunctional, and environmentally damaging. It's failing to stave off hunger, it gives rise to obesity in certain parts of the world, and is a contributor towards climate change. As you can see in these images here, the sector is responsible for around 18% of all greenhouse gas emissions. In South Africa, it uses up to 60% of the freshwater resources, and it is destroying habitats, putting thousands of species around the world at risk of extinction. But one of the most striking flaws of the current food system is its massive inefficiency, and it's this aspect that is most relevant for the purposes of this discussion. It's estimated that 1/3 of all food produced is never eaten, representing a huge loss of natural resources that went into its production. It takes an area the size of China to grow the food that is thrown away every year. If it were a country, food waste would be the third largest emitter of greenhouse gases behind China and the United States. Research has shown significant amounts of food are wasted everywhere, at all points of the supply chain and across all commodities. This is troubling, especially when it's estimated that 2 billion extra people will be added to our planet by 2050, which, according to reports that I've read, require a 70% increase in food production. So we really have to get more efficient on how we produce and consume food. Next slide, please. So there are two distinct concepts to recognize when we're talking about food loss and how to achieve the SDG goal 12, SDG 12 that I mentioned earlier. The one is food loss and the other is food waste. These are distinct concepts. First concept, food loss, refers to any food that is lost along the food supply chain. And examples of how food loss may occur is when rural farmers, for example, use sacks instead of hard coverings to transport their crops, giving rise to bruising and losses. Other examples include farmers using inefficient silos to store their grains, giving rise to spoilage and mold. The second concept to consider is food waste, which refers to the wastage of food resulting from decisions and actions by retailers and food service providers, and ultimately us as consumers. Here in South Africa, one means to avoid food waste is through retailers donating to NGOs and other charities. But food donors, I'm led to believe, are wary of Section 61 of the Consumer Protection Act, which provides for strict liability on a joint and several basis for producers, importers, distributors, or retailers for any harm caused by unsafe products. So it's important that best practice guidelines are followed when adopting measures that seek to donate food prior to its expiry. Retailers and other players in the value chain may also be reluctant to collaborate with each other for the common good out of fear of acting contrary to the Competition Law Act. But not all collaborative corporate action is contrary to this act, and this would have to be considered on a case-by-case basis. It's also possible to apply for exemption for certain actions in terms of the Competition Act. And as we saw with our recent challenges with COVID, it is possible to secure block exemptions, which are granted for the common good. And guidelines have been issued in other sectors on how to collaborate without infringing the Act. So this Act really shouldn't be an impediment to taking action. Next slide, please, Taryn. But aside from these considerations, which at first glance may appear to hinder an ability to take action, are there any other laws out there which are actively seeking to drive the minimization of food loss and food waste? And in this regard, the EU is a trendsetter, and I've set out some of the information on the slide. Governments representing half of the world population have set an explicit national target in line with the UN's goal to halve food waste by 2030, as I mentioned earlier. However, only those representing 12% of the world's population are measuring how much food is wasted. The EU has adopted the Circular Economy Package, including a revision of its Waste Framework Directive in 2018, and they have a new delegated act on the measurement of food waste, which was published in 2019. In 2020, the first EU-wide national measurement of food waste commenced. This will be reported back to the EU mid-2022 and will provide a comparative baseline measurement for all member states. The publication of this baseline data in 2023 is the anticipated date, will then provide the opportunity to consider the feasibility of establishing union-wide food waste reduction targets to be met by 2025 and through to 2030. For this reason, the 2020 period to 2023 will provide a crucial moment of opportunity for EU member states' food waste policy and EU-wide food waste reduction. Next slide, please. So in South Africa, we're doing something similar as in October 2018, as many members would be aware, financial support from the SA-EU Dialogue Facility, together with the Consumer Goods Council of South Africa, initiated the development of a food loss and waste agreement and roadmap for South Africa that culminated in the launch and implementation of a food loss and waste agreement. This agreement covers a variety of activities associated with food production, manufacture, retail, consumption, and waste management. Next slide, please. The agreement is more of a charter or a framework for action than an agreement. The agreement acknowledges that, like the rest of the world, accurate estimates of food loss and waste by sector are not currently available in South Africa. The main aim of the agreement is to establish a 2022 food loss and waste baseline for South Africa, against which progress towards SDG 12.3 can be monitored. The agreement sets out the provisional trajectory, as you can see in this slide here, that will be required to meet the SDG 12.3 target based on indicative data from 2022 as a baseline year. So establishing the baseline is a first step so that we have a handle on the extent of the problem. 2022 is around the corner, obviously, and we can anticipate greater activity in this area as we head towards 2030 and the target date for fulfillment of the SDGs. Next slide, please. But aside from the previously mentioned voluntary initiatives, are there other ways in which food loss and food waste may be regulated? Earlier I mentioned the ESG sustainable finance movement that is gaining increasing traction both locally and globally. The ESG legal framework is complicated and is in its infancy in South Africa, but is maturing. It's made up of a number of pieces of the greater ESG regulatory puzzle that seek to redirect sustainable finance to sustainable enterprise. The ESG taxonomy, we have a second draft of that in South Africa, identifies what would be considered a sustainable sector or activity based on a number of technical as well as legal criteria. This then allows investees to report on whether their activities are ESG aligned and allows investors to make business decisions based on those reports, to make decisions on where to allocate their capital in line with their ESG obligations. But it's the final piece of the puzzle relating to ESG due diligence that is potentially relevant. In South Africa, aside from the statutory duty of care in Section 28 of NEMO, we have no overarching piece of legislation directing entities to undertake value chain due diligence on their suppliers. In the EU, however, on March 10th this year, the EU Parliament adopted a resolution calling for mandatory ESG due diligence standards across the value chain for EU companies. We'll have to wait to see what comes of this and if and when an EU directive is gazetted, but this indicates the potential, at least, for the start of a regulatory trend of greater scrutiny down the value chain. Next slide, please. So in South Africa, as I mentioned, we have this draft taxonomy that seeks to set technical and legal standards for ESG-related alignment that companies can report on to attract investment. The technical and legal details in respect of crop production and livestock production have been pegged in the taxonomy as ringed here on the slide for future development. But to date, the technical and legal standards have not been developed. It therefore remains to be seen whether criteria relating to food losses will find their way into South Africa's ultimate taxonomy. Final slide, please. So in summary, we are faced with a massive challenge, both locally in South Africa and globally throughout the rest of the world, to deal with food waste and food losses. We are at the early stages of quantifying the problem, with baselines being set in South Africa and in other parts of the world, with the intention being to halve per capita global food waste at the retail and consumer levels and reduce food losses along production and supply chains, including post-harvest losses by 2030. At present, this is being undertaken through voluntary measures in terms of voluntary agreements in South Africa, but there's a business case for reducing food losses and food waste, as it makes economic sense to be more efficient and avoid losses, and it's also an imperative in terms of operating within our planetary boundaries. At present, as this presentation is sought to unpack, we don't have direct regulation in South Africa on food waste and food losses. We have a voluntary situation, but watch this space as the EU seems to be trailblazing with their initiatives, and it is possible that in due course we may have regulatory movements to require supply chain due diligence, and this area of the law may firm up within the context of the greater ESG legal regime going into the future. Thank you very much.
Thank you, James. I think we'll carry on with Carlyn, and then we'll go to Q&As. Over to you, Carlyn.
Thank you. Good afternoon, everyone. Thank you for joining us. And I'm going to deal with the extended producer responsibility regulations. And it flows slightly from what James was discussing, at least on the waste perspective, and moving towards ESG and the fact that companies are having to look more and more at their impacts on the environment. And the extended producer responsibility regulations obviously seek to try and achieve a circular economy, so to lessen the impact that waste has on the environment. Just going to share my screen so that I can get my presentation up. Okay. Great. Okay. Okay, can everyone see the screen?
Perfect.
Okay, great.
Yes, we can see it.
Okay. Again, obviously, I think just learning from James's presentation, if anyone struggles with seeing the slide that I'm talking to, just try and change it on your laptop specifically. Okay. So just to give a bit of background context, as James has already touched on, we have existing legislation which deals with items that the EPR regulations essentially focus on, and those are the environmental duty of care and the cradle to grave principle. And we have our framework legislation, the National Environmental Management Act, NEMO, which obviously deals with the fact that all individuals and companies have a duty towards the environment and to individuals to ensure that the impacts are minimized and managed where possible. And from those principles and from those obligations, the failure to discharge any of those obligations will result in, upon conviction, fines and imprisonment. In terms of NEMO, from a broad perspective, it's as high as 10 million rand and imprisonment for 10 years. And then the important aspect to add there, which I'm sure many of you are aware of, is the fact that directors can be held personally liable for any non-compliance or failure to discharge your duties towards the environment. And although we haven't had it tested in South Africa yet, the legislation certainly lays a basis for the potential for shareholder liability as well. So that's also important that obviously you comply with the duty of care. And more importantly, which I think James has also touched on in his presentation, where the world is going, it's really important to ensure that the impacts that you have are minimized and managed as far as possible. This certainly links to your reputational risk and your social license to operate. Obviously, consumers are far more aware of the impacts that products have on the environment, and it's definitely a selling point without greenwashing your products to focus on the fact that the environmental aspects of your operations are being dealt with and discharged.
Sorry, before you move to the next slide, I'm not sure. I'm getting quite a few people saying they can't see the slides at all.
Okay.
Is that the general view? Do we need to reshare, Taryn?
Sharing from Carlyn's side, I can see on this side. Perhaps we can just start again, Carlyn, if you want to.
Well, I'm seeing now.
Seeing
I
everyone
can
seems.
see from here. I can see.
Yeah.
All good. Okay. I suppose then carry on.
Okay, can see it
Okay.
again.
Sorry about that.
No, don't worry. I just want to make sure that I've got, okay, I'm just going to move that screen. Okay, so that was just sort of a framework that,
Yeah, okay, here we go.
okay, is it moving? Seems to be slower on my side now. Is it on to the next slide?
Environmental duty of care.
Yeah, so then let me try the next one. Okay, there.
There we go.
Okay, so the EPR regulations, just to give some context, I'm sure a lot of you are aware the fact that they already came into operation on Friday last week, on the 5th of November. So the purpose of this presentation is to just give a recap, highlight some of the aspects of the regulations, and then some of the potential issues that may arise, and comments that we're already seeing from clients just based on their initial impressions of the regulations. So the actual theory behind the extended producer responsibility is has been around for a while, and again, as James said, the EU is definitely they're thought leaders, and they progress these types of regulations, and they already started in the 1990s with EPR regulations. South Africa has also been dealing with it for quite a while, I think over a decade, and so this has been the culmination of many years of working with industry, but there obviously will be still some teething issues and some concerns between industry and government. And so the actual EPR regulations, they fall within the National Environmental Management Waste Act. And generally what the extended producer responsibility means is that those producers and manufacturers who produce a particular item now will be held financially and or physically responsible for the product to its post-consumer stage. So obviously the existing regime was that consumers and local government would have to deal with waste in particular, and there was no necessity, at least from a regulatory perspective, for the producers to have any type of manner in which to bring back those packaging or the waste products. Okay. So in terms of NEMO, we look at Section 18 and Section 69, and that's the sections in which the regulations were promulgated in terms of, and specifically we have a broader regulation, which is GN 1184, and that's the Extended Producer Responsibility Regulations. So that sets out the broad framework for the regulations, and then it goes to particular identified products so far. And there are two, and that's your electrical and electronic equipment, and then the paper, packaging, and some single-use products. And I'm focusing on the second, on the packaging sector. And most recently, we've had some draft packaging guidelines come out, which are, it's a period for comment. And what it deals with is it identifies recycling by design for packaging and paper in South Africa. So the idea, again, going back to the circular economy, is to design packaging that can obviously be reused, recycled easily so that it lessens the impact, especially on our landfills, which, again, many of you will be aware we are reaching capacity constraints, and probably in the next 5 years, those constraints will really come to a head. And so the more we can recycle and shift away our waste from the landfill will obviously benefit us. And then in order to deal with the EPR regulations, we generally look to identified products and then the actual definitions, whether they apply to your company and to your business. I'm not going to go through all of the definitions word by word, but essentially you would look to the definitions of producer and brand owner. And it deals with the fact that those identified products, which broadly speaking relates to packaging, whether that is produced and imported and then used by the brand owner or the producer. And in that instance, then you would have to comply with the regulations. There are some exemptions, which I'll look at in the next few slides. And so then there's your additional definitions, producer, and then as I've already touched on, producer responsibility. Sorry, I'm jumping ahead. The producer responsibility organization is an important one. That is your actual organization that will deal with the manner in which the packaging is collected and recycled, and from a financing perspective as well. So that will discharge all of the obligations in the actual regulations. Okay, so as I mentioned, to determine whether the EPR regulations apply, we look at identified products, then at the definitions and whether the company falls within the definition of producers. And then there are some, obviously the main thing for registration for last Friday would have been whether these products were on the market prior to the regulations coming into effect. And obviously if products come onto the market after the regulations, then there are further prescribed periods for registration following that. And then, as I mentioned, there are some exclusions, and that specifically deals with if the products are used for export only, then obviously they're going to go to other countries, and so the regulations don't apply. And another one, just before I start with the next slide, which is quite interesting as well, where producers or importers do not put more than 10 tons onto the market, then the actual identified producer in that instance would be your retailer. So that's also an important aspect just to remember. It's not set out, it doesn't really jump out at you, but it's a handy definition to look to. Okay. So then, as I mentioned earlier, if these regulations apply, registration took place last week Friday, and then again, they are just transitional regulations for those producers which obviously start producing after last week's date. Okay, oh, sorry, that went quickly. Okay, and then so the extended producer responsibility scheme, that's the actual implementation of the regulations. Companies have a choice either to establish that PRO, well, to establish it themselves and complete a particular form and register with the department, or there is the option to join existing extended producer responsibility scheme. And then for the two different options, there are slightly different obligations for those PROs. And again, both have to complete a form and register with the department. And just some basic requirements for your PRO is that they have to be an autonomous body and follow due process. They can't be for profit, and they must be managed by a board of directors. That has to consist of some representatives from the producers themselves. And then it is also necessary to deal and comply with the Companies Act for your good corporate governance and management of conflicts of interest. Okay, and then so some of the ongoing obligations, we don't have enough time to go into all of them, and there are quite a number, but I just thought I would highlight a few just to recap for those listening. One item is that products will have to have environmental labels and declarations for identified products in terms of specific standards. There's also, in certain instances, there is mandatory take-back of particular identified products at the end of the lives of that product. And that does often relate to the electronic goods quite specifically. And then there is an important aspect for producers to collaborate so that they can develop broad-based Black economic empowerment transformation charter within 2 years of the notice having been published. And then other items just deal with your life cycle assessment and the fact that products will have to be, the life cycle assessment will have to be done within 5 years from implementation of the relevant PRO and the scheme. And then throughout the life cycle of those products, you'll have to focus on the minimization of the material. This just comes back to the circularity aspect of the regulations, and then as well as the design of the product, which now there are some guidelines which have been published, and obviously draft guidelines for now, and then ultimately a reduction of the environmental toxicity of those products for the post-consumer waste stream. Okay. And then next with the penalty section, so to the extent that the regulations are not complied with, there is a basic non-compliance. So they haven't set actual penalties or years of imprisonment. So then we look to the Administration of Fines Act, which generally correlates with your magistrates courts and your high court fees. So I think at the moment the base or your lowest fine would be 120,000 Rand and 5 years imprisonment. So that just will change when that act changes. And then further penalties for those registered producers who do not comply, their registration can be revoked and they can be compelled to join another extended producer responsibility scheme. And for the actual PROs that don't comply, similarly, their registration can also be revoked. Okay, one of the biggest questions I think that a lot of companies who have to comply with these regulations have obviously had to deal with is whether to establish a PRO or join one. And unlike, I did some research and looked at the European system, and each member state deals with their EPR regulations in a different manner. But in South Africa at the moment, you obviously have existing schemes that have been established, but they deal with particular waste streams. So where you have a company that has multiple packaging waste streams, it becomes quite difficult to be a member of more than one PRO, and especially when you've got expenses and different requirements that you have to comply with for that specific PRO. And just to give a bit more context from the European perspective, obviously they've been doing it since the 1990s, as I mentioned, and they have some framework, a framework directive that sets out some minimum requirements for the member states. But to a large extent, each member state then has to implement their own legislation, and across the different European countries, there are quite a number of approaches. So there isn't one system. Also, based on their findings, there isn't necessarily one system that seems to be working better than others. And on that front, there are a few that have one single PRO. So it's a PRO that then deals with various waste streams, and then they correspond and they work quite closely with government and then the producers. Those countries, just for interest's sake, are Belgium, the Czech Republic, Ireland, Italy, France, Netherlands, Norway, Portugal, and Spain. And then other countries have varying degrees. Some have similar to South Africa, where it's a voluntary industry-led and quite competitive system, whereas others have different PROs in different regions, and some that deal with broader waste streams, some that only deal with specific waste streams. So it's quite interesting just to see that based on the number of years that they've been implementing these regulations, it doesn't seem that one is better than another, because it really depends on the context of the country and how those services and how the industries actually function. And the other thing I wanted to add just on the European system, it does appear that quite a lot of the learnings that they have had have been implemented into our regulations. But obviously, again, I think we will definitely see in the coming weeks and months how well suited the regulations are to the South African context, and whether it's going to work. I'm sure there will be some amendments and some changes, and hopefully all to aid the implementation of a more circular economy to avoid waste going to our landfills. And then the last item I just wanted to highlight, so some of the items from our clients that have also come up, one idea or one comment was based on the duty to separate at source. And that aspect isn't dealt with specifically, but I believe that it's going to come into the context of educating consumers, as well as dealing with the municipality and also our waste pickers that obviously have not a voluntary, but they aren't regulated at the moment, but they obviously fill quite a gap in our industry where they separate quite a lot of waste. So I think it's just going to be up to the industry and government to try and educate some consumers, obviously where they have better systems in places and they can actually separate and have, whether it's the municipality or other independent waste contractors come and collect those items, versus areas where that is not in place, then I think it will rely a lot on the waste pickers as well. And as I already mentioned, another issue which is likely to come up is just the regulation of the PROs. They have different rules, different costs, different fees, and they obviously deal with specific or different waste streams. So I think that will definitely be heavily debated, and it will be interesting to see how they all function. And finally, what to expect. As I mentioned, I think it is an evolving space and something that has been in the works for a while, but it's an opportunity for industry, for consumers, for government to come together and really think out the box, innovate, and try and get a handle on our recycling. And there's room for jobs. There's obviously added administration, which is not ideal, but I think it's going to take a while and there will be teething problems, but as long as everyone is on the same side and willing to do what they can to implement it, I think it will be very interesting to see where it goes. Okay, and that's the end.
Thank you very much, Carlyn. I think, you are right. There will be teething problems. We're already starting to see some. What is encouraging is that the relationship that we've built as the Consumer Goods Council with the department in particular is a great one. You remember that last year around this time, the minister was ready to go ahead with the regulations. But we wrote to them and said, Minister, there are things that have not been taken into account in the draft, and therefore the regulations as they were presented could not be implemented. And they agreed as the department to form a joint industry and government task team that looked line by line at the regulations until it was fixed. And hence the promulgation was pushed out, and I'm encouraged that there is that type of collaboration still happening with the department. The one thing that you mentioned about the multi-PRO for the various waste streams or single, it's gonna take a while because we've been in discussions, for example, with packaging South Africa, wherein you already have EPRs that are in existence, but they are cognizant of the fact that the last thing that they want to do as PRO is to create an administrative burden for producers. And as far as practical, we will work together to ensure that it becomes a seamless process over the years until we can get to a point where we all understand what is required. There are some questions, and just on the fees, sorry, lastly, we are told that the fees have been, the different PROs have submitted their fees to the minister for her consideration, and I think she's going to take about 60 days to review them, and the final publication will be done possibly, I think, Tsukuluho, you said January, early January, and depending on the public holidays that are coming, but I think it's going to be around the 5th of January, or just a week later than that we will have an indication of what the actual fees that have been approved of by the minister are. So going to the questions, let's start with sorry, I'm going if a company, can you confirm the 5-ton threshold for packaging and the retailer becoming responsible in this case? I think they're saying there that they haven't heard of the retailer becoming the responsible party. Is that in fact the case? And can you confirm that? The second question, I'll just gonna ask if you, I think is to you, James. It has to do with the Section 6(1) of the Consumer Protection Act, where we've had a number of our members saying that issues of food waste are a challenge. A lot of food goes we know wasted because restaurants, retailers cannot really give away that food for fear of the fact that there might be some contamination cases down the line. And if, for example, Pick n Pay donates food, the chairperson of Pick n Pay becomes personally liable if somebody is sick. What can be done to the Consumer Protection Act to enable, issues of food waste to be dealt with? We know at COP's 26 now that this was a major item on the agenda, and the world is moving towards enabling that environment for, food banks, not just food banks, but retailers and restaurants to be able to close the loop in terms of food that goes to waste. And sometimes it's really, really good food. It's still good, may not have passed that may have passed the sell by date, but it's it's not food that can still be dumped. And then just for you again, Carlyn, they're saying that the fines that are currently published seem to be quite small. Do we think that there can be civil claims as well? And maybe let's stop there for now, and then we'll take another round.
Perfect. Thank you for those questions. I've just slotted in the definition that I was referring to. It's quite long, but sorry if I said 10 tons. It's in the definition of producer itself, in the regulations for paper and packaging. So it's in that specific regulation where you look at the definition, and it mentions that producers who place in excess of 10 tons of identified products onto the market on an annual basis responsible for the extended producer responsibility shall be identified subject to the following criteria. So then it goes off into two different options essentially, where it deals with branded goods and the fact that the company is registered in South Africa. I'm not going to read the full detail just because it might take up some time, but the part where it goes into an exclusion per se is that if it's not any of the items A, B, or C, then just trying to find it here. I think I've cut it off. I'll put the definition in again, but essentially then it says if any of those items A, B, or C do not apply, then the retailer will be the relevant producer. So it's specifically where less than 10 tons of that identified product, so it's the packaging itself, is put into the market. I hope that answers that question. I'll just try and put the definition a little bit clearer. And then just on the fines, they, Altair, thank you, just noted the increased fine. So it's actually a little bit higher than I had mentioned. So it's the starting fine is 200,000 and for 5 years, and then 600,000. And as far as a civil claim is concerned, I'm not actually sure. I don't know if James would have an answer to that, but I think it would have to then tie into sort of the broader duty from a waste hierarchy perspective in terms of NEMO and whether an individual would be able to take a company on from that perspective. We do have private prosecution that is possible in terms of NEMA, but where we've seen that used in particular is, for example, Section 24G, where companies fail to get authorization for impacts for development, that type of thing. So it's quite a good question and something I'll definitely look into.
Well, thanks, Carlyn. While you're considering that fine question, Dave, James, somebody wants to know if the fines apply per category, and in other words, bottles, plastics, or whatever, or is it just one fine that a particular company get? I would think that it's for the different products, but you can please include that in your response. Thanks.
Sure. Then just to respond to the question, Section 61 of the Consumer Protection Act, and what you can do about it. So yeah, I'm aware that this is perceived as being a massive hindrance to the ability for retailers to donate food, and understandably so, given the liability that is provided for there. And I guess the question was, what can you do about it? And yeah, in preparation for this presentation, I had a look around to see what was out there, and I saw that the Consumer Goods Council had published a guideline document on what to do that came out last year, October, it seems. And I thought it was quite a useful document in terms of setting up your systems. I think it's important to have the right paperwork in place so that you are, donating what is actually safe. Obviously, nobody wants to be donating stuff which isn't safe for consumption, regardless of who is going to be consuming it. So having your processes fine-tuned with a paper trail, I think, is an important first step. And then, have your contracts in place, even though you can't contract out a statutory liability. Having a good contract in place with whoever you're donating to, I think, is also an important aspect, because you want to try and limit your exposure from the point of donation to the NGO. It might be that the NGO sits with the food beyond its use-by date, and then you get pulled into that net. So yeah, short of legislative amendment, I think those would be the types of recommendations that are out there at the moment that are worth considering.
Thank you. And I think it is the legislative amendments that we think we really want to push for, because I think anything else is very short-sighted, bearing where the rest of the world is going, and the fact that we live in a third world country where issues of food waste and hunger and food security are real issues of real concern. I'll carry on with the questions. It says, if a company has registered as a producer in terms of the air, but wants to implement their own EPR scheme, do they also need to register as a PRO?
So my response to that would be yes. The regulations don't specifically deal with amendments or changes, but I believe it would, James, unless you have a different view, it would be a notification to the department indicating that you're obviously withdrawing from the existing PRO and establishing your own, and then yes, have it approved and comply with the relevant obligations.
James, do you want to come in there?
No, I agree. So yeah, I don't have anything further to add other than to say I completely agree.
Yeah, that's the indication that we're getting as well, just to confirm what you're saying, because in our discussions with the department, that's what we've been told as the Consumer Goods Council as well. It says you made reference to labeling obligations. Do the EPR regulations speak to the current labeling laws under the Department of Health FCD Act?
I'm not sure on that point. I'm not sure if James does or even Altair, but it's something that I will double check. When we prepared the slides, it was more the SAN standards that we saw references to.
Okay, I'm not sure from that perspective as well. One says the department has advised us that as a brand owner, we do not carry the obligations of a producer. Can you confirm that this is the correct understanding and interpretation of the regulation? So the responsibility will be with our supplier to ensure that both recycling content and recycling rates are in accordance with the regulation.
Yeah, correct. So where the brand owner comes in is where they import their own finished products, for instance, and it's already in one of those identified products. So the plastic or the glass, and obviously then you can't rely on the third party who has produced that packaging, because they won't be in South Africa. So in that context, that's where the brand owner comes into play specifically with the regulations.
Yeah, okay. And last one, it says, regarding the fees, what role can the industry play in determining the fees? The current fees that have been seen so far are exorbitant.
I'm not sure. I think
I suppose that, Carlyn, if the minister is considering, and this is an if, we'll have to come back, as the Consumer Goods Council, if the minister, with the closing date of the 5th last week, is currently considering the fees and they're going to be published, we're hoping that, there's going to be a public consultation process. I might be wrong. But we would need to follow up, and we'll let our members know what's the next steps, after the minister has considered the fees. Does it mean that once she's seen them, they become, the fees that apply, or is industry going to be given an opportunity to do so? We'll get clarity. Like you said, there will be teething problems. We're all learning in this environment, and hopefully we'll get, everything sorted out soon, but we will let our members know.
I agree with you, though. From an administrative sort of fair procedure perspective, there should definitely be an opportunity for the industry to comment on those prices.
Yeah, because if you look at the Agricultural Product Standards Act with the assignees, that's basically the process that the Department of Agriculture follows as well. It doesn't mean we agree with the fees, but there is at least a consultative process that's been put in place. Not sure if there's any more questions. Otherwise, we thank you very much, James and Carlyn, for your presentations.